This lecture covers the legal frameworks for business transactions and economic development. Economic development is synonymous with the proliferation of business transactions, and the legal frameworks relevant to business transactions must be carefully studied. Such legal frameworks include a wide range of private and public laws, such as contract law and laws governing property rights, government regulations on business transactions, and secure transactions. This lecture examines the legal frameworks for business transactions in the context of economic development, with an emphasis on contract law. We will also cover a section on secure transactions. The secure transactions are another important device that creates a legal interest, security interest, in property to secure credit. Secure transactions are promoted as a means to enhance business transactions. A contract law defines formation of contract, how a contract can be formed, validity of contract, which contract is valid under the law, and which contract is not. A contract law also clarifies the rights and obligations of the parties. It defines the forms where a contract requires a specific form. The contract law also provides for defense to an otherwise valid contract. So what constitutes a legal defense to an otherwise valid contract? Protection and enforcement of the contractual rights and obligations are important for business transactions and economic growth. Such protection and enforcement improves the predictability of transaction outcomes and reduces transaction cost. So when the parties are clear about their rights and obligations, they can readily predict the outcome of their transactions, and that clarity reduces transaction cost. Whereas parties are not certain about their rights and obligations, even if there is a contract, then obviously the parties will have to consider ways to enforce or guarantee their rights under the contract, and it tends to reduce the predictability of the outcome, and it'll raise transaction cost as opposed to where the rights and obligations are clarified and secured under the law. There are two contrasting views about the importance of contract law and formal contract enforcement. According to one view, the contract law and formal contract enforcement, referring to a form of contract enforcement performed by the state under the terms of the law, are essential to economic development. Leading scholars such as Douglas North and others have emphasized the importance of the contract law and formal contract enforcement. According to another view, however, the contract law and formal contract enforcement are not as essential. They argue that the majority of issues and difficulties arising from business transactions are resolved informally without making any reference to contractual terms. So other scholars, such as Michael Trebekov, has argued that formal contract law and contract enforcement by the state are not as essential, particularly in the early stages of economic development, as demonstrated by some cases such as China. So we will study these contrasting views and see whether these views can be reconciled. There is a need to consider an appropriate regulatory approach, i.e., to what extent the state must use its limited resources to develop formal contract law and enforce contracts to facilitate economic development. It is a particularly important question for developing countries facing resource constraints. We have to review relevant points, such as contract validity and formation issues in the context of economic development, views that support or detract from the role of formal contract enforcement in economic development, the conditions required for the regulatory frameworks for contracts that is conducive to economic development, limitations on contracts, such as limitations on the freedom of contract for public policy considerations, such as economic development, and secure transactions. We will review these points in the remainder of this lecture. Contract law provides a legal foundation for business transactions, and contract laws around the world seem to have common elements, including formation. A contract law tends to define how a valid contract can be formed. Validity, again, which contract is valid under the law and which is not. The rights and obligations of the parties. Contract forms, if required. And defense, what constitutes a defense to otherwise valid contract. These seem to be a constituent elements of contract law around the world. Also, private property rights form the essential basis for valid contract transactions. Without clearly defined private property rights, contractual transactions will become difficult. For example, if parties wish to sell and buy a house, in a place where the house ownership is not clearly defined or enforced by the law, the contract transactions based on the selling and buying of the house will become very difficult. And without well-defined contract laws, the property will not be able to move. So private property rights and contracts are two key elements for the market economy. And in this, both property rights, contracts are important for economic development, because without vibrant market transactions, economic development will become difficult, and without clearly defined property rights and the contractual transactions, it'll be difficult to promote business transactions leading to economic development. There is a question of subject matter for contract. What can be contracted among private individuals? There are liberal and restrictive approaches. Liberal and restrictive approaches. In the liberal approach adopted by the market economy, individuals are permitted to contract with one another over any subject without general restrictions. So in the market economy, the individuals will be able to contract, but not over a legally prohibited substance, because there is a particular legal prohibition of the substance. So this illegality will prevent forming a valid contract over this substance. In other words, without specific legal prohibition, in the liberal approach, parties will be able to contract without general restrictions. The opposite approach will be the restrictive approach, which was adopted by the communist regime. In the restrictive approach, contractual capacity is broadly limited, generally limited. So in the communist system where property ownership is prohibited, the parties will not be able to contract over selling or buying a factory where private ownership of a factory or other productive facility is not allowed under the law. Contractual capacity can also be controlled by license. So in the development context, export and import licensing can control who can have a contractual capacity over certain business activities. So for example, in a country where importation of certain goods is very popular and demanded by consumers, government can control contractual transactions in this area by granting licenses to a certain group of qualified parties, individuals and corporations. So if a country wishes to promote export as a development strategy, it can actually enhance export by imposing license on lucrative import, which is demanded by consumers in the country, by linking import license to strong export performers. In other words, if an individual or a company wishes to get lucrative import license by the government, it'll have to show strong export performance. And by doing that, the government can expect increase in exports because there is now motivation for increasing exports among the corporations and producers in order to get lucrative import licensing. Also, license and the revenue from licensing will become a potential revenue source for the government if terms of the license require payment of tariffs over the goods imported from other countries, then that tariff will become a potential revenue for government. License can also be imposed in other ways. So the government wishes to restrict land transactions where the land prices have been hiking, perhaps as a result of successful economic development. So as a result of economic development, large number of jobs are created in certain cities, and the government sees a large influx of population, the immigration of population into those places, which results in the rapid increases in the housing prices. So if the government feels the need to suppress the increase of property prices, housing prices, it can require authorization for land transactions to suppress speculation, perhaps. And this is also the form of license that can affect and control contract capacity in this area. So in this situation, those who wish to buy or sell land in a highly demanded area will have to get an authorization or permission from the government. And contract signed without such government authorization will become invalid. So this is one other case of government control over contract capacity. So the government can control the scope of legal business transactions by using licensing and authorization schemes. There are also technical issues involving offer and acceptance in contract law. Issues, for example, would include a validity of an offer. So, for example, in common law contracts, the terms of an offer must be clear and definite to form a valid contract. So if one wishes to make an offer, the offer must include all the essential terms. So for instance, in a sale of good, the offer should include in common law all the relevant terms such as quantity, price, delivery terms, payment terms, and also in common law, acceptance of such an offer should not vary the terms of the offer. In other words, acceptance must mirror exactly the terms of the offer and should not attempt to change any term in the offer. So when an acceptance fails to do that, so acceptance tries to change the term or reject part of it, then acceptance will fail and there will be no contract. However, in some cases, parties may do this. A party may fail to accept the offer by raising an objection or by failing to mirror the exact terms of an offer without necessarily intending to break the contract. So, for example, a party may offer to sell a house for $200,000. And the other party to whom offer was made may well say, okay, how about $250,000? Then in this case, obviously, negotiation goes on, negotiation proceeds. And then there is no contract under the terms of the offer because the other party did not accept $250,000 offer. But in another example, where a party offers a computer for $2,000, and the other party wishes to accept the offer, but adding a term by saying, okay, I will accept your computer. I will agree to buy your computer for the stated price, but I will ask you to clean up the computer, which is a minor task probably before you did that. Now, in the strict interpretation of common law, because acceptance has to mirror exactly the terms of the offer, adding this term, clean up your computer, may constitute a counteroffer. And what happened was, without necessarily intending so, the party may have destroyed the offer. So no contract results out of this. So to facilitate economic development, perhaps a more liberal approach might be helpful in the assessment of offer and acceptance. So in the United States, a Uniform Commercial Code, UCC, that aims to adjust common law and making it a bit more flexible, was says that the adding a term to the terms of an offer may not necessarily break the contract. And a valid contract can actually be formed even if the party fails to accept the offer as exactly offered, even if the party may vary or even attempt to change the term of the offer, the contract is not necessarily broken. So this is a helpful approach in economic development. I'm not going to get into the details of the UCC at this point, but it is helpful to know that in an effort to economic development, regulatory adjustment, the legal reform that relaxes the terms of offer and acceptance, how contract can be formed, so perhaps relaxing the terms of contract formation might be helpful. What about contract enforcement? So we have seen the potential issues with contract law, and we need to look at the formal contract enforcement. The formal contract enforcement means the enforcement of contract by the state under the terms of the law. So as mentioned, the contract forms a cornerstone of the market economy and economic development, but it's not going to be very effective unless its terms are enforced in the case of breach, because failure in contract enforcement will leave the non-breaching party with no remedy. There are two methods of contract enforcement. One is private enforcement, and the other is formal enforcement. Private enforcement of contract involves a no state agent, such as a court. It's an enforcement done by private parties, employing potentially various means, such as a third-party collector. So the non-breaching party may engage a third-party collector, or the non-breaching party can issue a warning to exclude the breaching party from further transactions unless adjustments are made. Or a non-breaching party can warn a bad review on the internet, for instance, or self-help, taking possession of the good. The problems of private enforcement is that it may or may not be legitimate under the law. So if non-breaching party takes the possession of the good, it may or may not be legitimate under the law. Private contract enforcement can be costly. The cost of hiring third-party collector. The outcome will be unpredictable. So warning to exclude the breaching party from further transactions may or may not be effective. The breaching party may or may not care about the bad review. And also risky, particularly when a chosen method is illegal. So private enforcement tends to increase transaction cost, deferring investments. So formal contract enforcement mechanisms employing the state agencies such as a court developed in all of advanced countries such as OECD countries. However, formal contract enforcement doesn't seem to necessarily guarantee a speedy resolution of contract disputes or enhance expediency in contract enforcement. So if you look at the table on the screen, it shows some tendency between the duration of contract enforcement vis-a-vis the level of economic development. So if you look at group 1, Singapore, obviously a developed country economically, shows 164 days to contract enforcement versus Bangladesh, group 3, still developing country. It takes 1,442 days of contract enforcement, showing clear contrast. But then again, Greece, for example, is also considered economically developed country in Europe, takes 80 days versus, let's say, Vietnam, still a developing country, taking 403 days. So there is some tendency between the duration of contract enforcement and economic development, but the correlation is not precise necessarily. What are the issues of developing a system of formal enforcement? A considerable institutional capacity is required. In other words, substantial financial, technical, and personnel resources to set up and maintain the judicial system. For effective adjudication of contract disputes, it is necessary to identify appropriate remedies and enforce against the breaching party. Could this be achieved by improving the judicial system? The push for judicial reform to improve formal enforcement without due consideration of the state's resources and capacity proved to be ineffective, and there shows no result in effective enforcement, especially after aid is completed. And also, it is reality that the vast majority of business disputes are resolved without resorting to contract law or formal enforcement in both developed and developing countries. And the absence of effective formal enforcement does not necessarily lower investments and impede economic development. And there is a cost of enforcement, and the risk of contract breach is only a part of the cost assessment for investors. So that explains the fact that the contract breach and cost of enforcement is only a part of assessment. Has been demonstrated, at least to some extent, by an increase in foreign investments in China. So China, since the 80s, for a substantial period of time, did not really show effective formal contract enforcement, but nonetheless, there was a substantial increase in foreign investment in China due to the economic and market potential of China, despite the potential weakness in the contract enforcement system. According to a research done by Michael Treblecock and others, lack of formal enforcement has not been necessarily a barrier to economic development in the early stages of economic development. According to research, a formal enforcement seems to be more relevant in the later stages of economic development, where transactions become more complex and have to be done outside the small communities. So informal business arrangements and private enforcement based on community networks and personal ties become less effective in the later stages of economic development, where increasing complexity of transactions and more transactions outside the community networks emerge. So by that time, the community common business practices or traditions in small circles are not necessarily shared among now broader business partners outside those community boundaries. And at this point, the formal enforcement seems to become necessary. Also, I've mentioned the need for institutional capacity and resources to develop formal enforcement, and these resource needs tend to be met in the later stages of economic development. So gradual approaches are perhaps recommended. There is no cut-off point or universal guideline on the timing to develop formal enforcement systems and when the necessary investment must be made. Where is that cut-off point? There are cases of developed countries favoring out-of-court adjudication over formal court proceedings, as observed in the case of Japan. So in order to transition over to more formal enforcement, there has to be a need in business transactions, and there has to be available resources to make such a transaction. So there might not be a clear cutoff point, but as economic development proceeds, and if there is a need for more formal enforcement because the broadening and expansion of business transactions beyond the traditional communities and close personal nets requires such formal enforcement, then obviously the transition has to be made. Transition to formal contract enforcement has to be made, and there has to be also the resources available to make such a transaction. So a strategy for developing countries emerge out of this discussion. Effective country enforcement is conducive to fostering business transactions, but it's not conclusive whether formal enforcement is imperative to economic development, particularly in the early stages of economic development, where a majority of transactions are based on community networks and informal arrangements. As shown by the development process of East Asian countries, expansion of economic transactions and globalization necessitates formal mechanisms such as a contract law and formal enforcement. There's a case for gradual adoption of formal mechanisms in pace with available resources as a working strategy for developing countries. So there is a necessity for flexible regulatory approaches, which allow both informal and formal enforcement mechanisms to the extent that these two mechanisms do not conflict. So, for example, arbitration and non-binding mediation could be broadly employed to address contract disputes. The strategy for developing countries could also include focusing on recurring problems in business transactions that may have an effect of suppressing economic growth. So if loan fraud is a prevalent problem in business transactions, then perhaps the legal development can focus on how to prevent such a fraud and how to effect effective punishment against those who commit the loan fraud. So in the case of South Korea, for decades, writing a bad check over a certain amount constituted a punishable crime. Now, there can be a controversy as to whether or not the civil offense, such as writing a bad check, should be criminally punished, but nonetheless, that legal approach had an effect of suppressing the prevalence of bad checks. Also, if a credit is an issue, assessing credibility of a party could be an issue, and law can also focus on the development of a credit reporting system. IIAs, international investment agreements, have also become a device for investment and economic development. IIAs set forth enforceable contractual terms between the government of the host country and foreign investors of the signatory country. The terms of IIAs include the MFN, most favored nation principle, non-discrimination principle against foreign investors or among the foreign investors, the national treatment, again, non-discrimination between the domestic and foreign investors, protection of foreign investments, so restriction against arbitrary taking of foreign investments. The downside of the IIA includes restriction of policy space by requiring MFN, national treatment, and protection. It works against the government policy that favors domestic industries, such as a subsidies limited to domestic industries to foster domestic producers. And if the terms of IIAs restrict them, then it'll work as a restriction of policy space for domestic economic development strategies. So developing countries must carefully weigh the benefit and cost in concluding an IIA and set the terms to ensure that the IIA does not preclude its key development policies related to investment. So if the developing country wishes to promote domestic telecommunication industries, then it'll have to ensure that the terms of IIA does not prohibit setting certain protection for domestic telecommunication providers. As discussed before, the contract capacity can be controlled by the government. So government can impose contract limitations for strategic development needs. So, for example, the government can limit contract capacity to protect strategic natural resources by placing certain limitations on import and export transactions. So, for example, in 2009, China imposed export restrictions in multiple forms, including export duties and export quotas on rare earth minerals such as bauxite and fluorspar, which is used for a range of modern industries such as chemical industries and ceramics. Now, these natural resources were strategically important for certain industries, electronics, and the China imposed these restrictions to protect its own natural resources. The importers of these natural resources have filed complaint with the WTO, World Trade Organizations, about China's restriction measures, and the later WTO found that China's measures were not compliant with the rules of WTO law. But nonetheless, it is an example where the government has placed limitations on contract for strategic development needs. As mentioned, the land transactions can also be subject to licensing by the government for development-related purposes, to suppress housing prices, to support laborers and the residents. So that could be an example of contract limitations related to economic development. I have also discussed licensing schemes, granting import license in accordance with export performance. And again, this is another example of government-induced contract limitations for strategic development needs. But licensing schemes have a more general effect on the freedom of contract beyond international trade, though. Licensing schemes set limits on those who can engage in certain types of contracts, and such schemes have a general impact on the freedom of contract and the economy. So it has to be used with caution. And there is a necessity for coordination with economic development policies, particularly in the early stages of economic development. So contract limitations and licensing schemes affect business transactions in general and have an impact on development strategy implementations, but coordination is the key point. The limitations and the development strategy will have to be closely coordinated, minimizing side effects such as undue interference with business transactions. Now, control can also be based on the basis of public policy. Now, contract limitations based on public policies to correct unequal bargain powers between the parties. So, for example, consumer finance, the parties such as individual consumers have very little business leverage against those who provide finance to those consumers, the banks and other financial institutions. And the contract limitations can be imposed to correct this bargaining imbalance. So in this case, the contract limitation is not prohibiting contract or limiting contract, but rather requiring a party with superior bargaining power to explain and clarify the terms that affect the interest of the other party with less bargaining power. So in consumer finance, requirements such as to clarify the annual interest rate will be an example of such a limitations based on public policy. For insurance contract, again, the requirement to clarify the terms of coverage by the insurer would be such a limitation, in that the insurer cannot write the contract in 100% as they want, but they have to comply with the government rules of certain exposure and clarification for the benefit of the insured. That is to correct the unequal bargain powers between the parties for social purposes. Also, in the early stages of economic development, there is a lack of supply competition. So the certain suppliers might have a monopoly power in the economy. So that requires addressing the unequal bargaining power by empowering the state, enabling the state to intervene in a contract on behalf of weaker customers. So again, if the market controller, those who have monopoly power, wishes to set a contract terms, but those terms will be subject to potentially government control to ensure that a fair transaction will take place between such a powerful supplier and relatively weaker consumers. So, for example, dominant the market supplier may not include contract term that eliminates all of its responsibilities for personal injury, for example, that will not be allowed by the government if the government limits the contract capacity of the dominant market supplier for exemption of their liabilities, right? So again, not every country does this, but government may impose a certain limitations on the terms of the contract for the cause of public policy. And contract can also be rescinded for state action. So if the government expropriates a property for a public purpose, then the contract to buy or sell such a property subject to expropriation between private parties will not be enforced. So the government has a power to have such a contract rescinded. But again, the rampant application of government power to expropriate will raise an issue for market transactions. And so there is a need for caution in implementing government powers such as expropriation in this case. So for any reason, could there be a case of general restrictions on the freedom of contract? Now, general restrictions, not limited restrictions, but general restrictions would be unfeasible and unproductive in any stages of market-based economic development. The freedom of contract is at the core of market transactions, and it is necessary for economic development. The proliferation of market places in socialist North Korea is a testament to the importance of contracts and market transactions. And it shows the freedom of contract is indeed essential for economic development. There has to be a point of balance between protection of freedom of contract and promotion of public interest, including economic development. There could be a greater restrictions on contracts in the early stages of economic development for strategic development policy needs. But even in this case, in successful development cases, such as East Asian countries, courts generally protected the freedom of contract principle and safeguarded the general freedom in market transactions, which was conducive to overall economic development. The last segment of today's lecture is secure transactions. Secure transactions refer to a loan or a credit transaction in which the lender acquires a security interest in collateral owned by the debtor. A former U.S. Secretary of State, Hillary Clinton, described the importance of secure transactions reform. It's in the book, so I'll just read the quote. We are also working on reforms with OAS, that's Organization of American States, to update what is called the Secure Transactions Law. She continues, now put simply, this is to allow small businesses and entrepreneurs to use assets like refrigerators or sewing machine as a collateral for loans. Many of these businesses could grow and employ more people, but they don't own the property that they work in or the home that they live in. But they have a refrigerator or a sewing machine, and we want to change the laws so that they can serve as collateral. So as Secretary Clinton explained, secure transactions create a security interest. That is a preferential right to possession or control of personal property to enhance access to credit. So a single property can be used to support a series of loans. A debtor does not have to have title to the property. Any property susceptible to monetary valuation, whether present or future, tangible or intangible, may create a security interest. A security interest may be created by contract. So the contract is relevant to secure transactions. In secure transactions, the protection of a third party is essential because if a individual wishes to collateralize his or her sewing machine, the third person, potentially a creditor, has to know whether the debtor, has indeed a right, to the sewing machine. So the protection of third parties is essential for secure transactions. And for this, public notice is important. How does the debtor, potential debtor, make such a notice? By possession or control of collateral, or by registration. So the possession, or lawful possession, raises a presumption that the debtor has the right to the product, to the good, and the control. But the registration is also important means to provide such a notice. For registration, the priority is created by the time of filing. So who filed first? In order to determine whose interest has a priority over the item subject to the collateral, the time of filing tends to control. So case for secure transactions is such that secure transactions may contribute to economic development by creating access to cheaper credit. And as I've mentioned, a security interest is created by contract, the terms of which specify the credit arrangement between the parties, including the duration of the loan, payment of interest, repayment of the principal, and disposition of the collateral in case of default. So credit can be generated on this relatively clear contractual terms. So a number of international and national development agencies have promoted secure transactions that include UNCITRAL, the United Nations Commission on International Trade Law, Organization of American States, Organization for Harmonization of Business Law in Africa, the European Union, the World Bank, USAID, all promoted secure transactions. But nonetheless, there are clear limitations as well. There's a question of effectiveness of notice and cost of setting up registration system. Development and operation of an effective registration system in developing countries have proven to be a challenging task. For example, in Peru, there were 17 registries for different kinds of assets, each with its own regulations and requirements. And such a system was considered to be a recipe for confusion and uncertainty. So there was a considerable difficulty with setting up an effective registration system, especially in developing countries facing resource constraints. There is also a possibility of conflict between communal rights in a property and the security interest created through a formal mechanism. So the formal registration entry may not reflect on communal rights in a property, thereby undermining the rights and interests of these other parties involved in such rights. So legal facilitation of secure transactions must be done in careful consideration of informal property rights and local law and practice. There's also another question that whether a small-scale consumer loan that can be created by secure interest could indeed become a vehicle for economic development, i.e., has any developing country achieved a degree of economic development based on secure transactions? So in contrast, if you look at the successful cases of East Asian countries, it was a large scale, the government-backed loans and investments, rather than small-scale consumer loans created by secure transactions that financed successful economic development. There is also risk for people. Secure transactions may create easier access to credit, but it may exacerbate rather than alleviate poverty. There's a risk of non-payment, and non-payment will lead to the loss of property. The small collaterals can be used to encourage predatory lending practice in reality. So instead of gaining credit to induce wealth and alleviation poverty, it can actually exacerbate poverty by causing non-payment, loss of property, which will be caused by predatory lending practice. So again, secure transactions have a merit. It can have a function of creating credit for those who need it, but implementation and development of the system has to be carefully cautioned and promoted against in full consideration of this risk. I'd like to draw a few final points based on these discussions. Legal framework for business transactions, such as contract law, may contribute to economic development and reduces transaction costs by clarifying and protecting rights and obligations of the parties to transactions. The contents of contract law tend to have universal elements, but should recognize prevalent local practice to increase applicability and effectiveness. There is a case for the promotion of formal contract enforcement. However, evidence does not necessarily support that it is essential for economic development, particularly in the early stages of economic development. Informal contract enforcement should be recognized and utilized in the early stages of economic development. Formal enforcement becomes more relevant and necessary in the later stages of economic development. Secure transactions may indeed facilitate small-scale credit access by enabling small businesses and individuals to leverage their personal property to obtain credit, but it is not certain whether the facilitation of small-scale loans would be an adequate substitute for the large-scale investments necessary for successful economic development on a national scale. So, in developing and implementing secure transactions, the cost-benefit analysis is necessary. So this concludes today's lecture. Thank you very much.